Welcome everyone to this Privacy Rules Privacy Espresso. My name is Alessandro Di Mattia, Legal and Executive Officer at Privacy Rules. And today I'm joined by our expert from the law firm Frost Brown Todd based in the US, that is Yugo Nagashima, that I thank for being with us today. In order to discuss about the new and recent draft adequacy decision made in relation to the EU-U.S. Data privacy framework. That is a very hot topic of this moment. So let's start with a little background on what happened, maybe.
Sure. Thank you so much for inviting me, Alessandro. So on December 13th, the European Commission launched a process to adopt the adequacy decision for the EU-U.S. data privacy framework. And this is, again, a draft, but this draft, as we see, concludes that the United States ensures an adequate level of protection of personal data transferred between the EU to the US.
Okay, and why these happen now in this historical moment?
Yeah, that's a very good question. Why now, right? So if you remember, in March, there was an agreement between President Biden and the president of the EU. And then we haven't heard much, and a lot was in mystery. But President Biden signed an executive order on October 7th, I believe, which implemented the agreement in principle of the new EU-U.S. data privacy framework.
And speaking about this, what exactly, an executive order, and what was this implementing specifically?
For those who are not, in the U.S., an executive order is a presidential order. It's an administrative order from the executive branch. So it doesn't have to do anything with Congress or lawmakers. It's just the president saying, these are going to be the regulations. And it basically introduced new binding safeguards that address concerns from the Schrems II decision, the judgment that the CJEU said that the old U.S. privacy shield was not good enough. So this imposes certain limitations of how you can access data, and puts in certain safeguards of European Union data from protecting from U.S. intelligence agencies, and also having a more robust, independent, and impartial redress mechanisms so that the U.S. can be in line with the GDPR to get adequacy.
That sounds perfect. So basically, if I understood it well, the executive order will be used to implement and to reach out to an adequacy decision. So what does it mean for U.S. company? Which are the principles that have been transferred through these?
The good news is, again, this is only a draft, but if it is implemented, it would allow the free flow of international transfer of personal data from EU to a country that's adequate, right? Third countries that are adequate, and US would be one of them. So you would not have to have certain safeguards that we currently put up, the additional safeguards, as we know, like standard contractual clauses we use or binding corporate rules. And of course, that means, less worries for US companies, because that process of, negotiation would probably be lessened. But that said, we can discuss that a little more later.
Yeah, and in particular, we were opening the topic of the principles. As we know, GDPR, the EU regulation, has many different principles that are involved, and I suppose and assume that the step that US is taking is getting closer to those. Speaking about some of them, one that was very important is the one, for example, of purpose limitation. Well, can you share with us about that one?
Right. So the EU-U.S. data privacy framework also has a very similar purpose limitation and choice principle. So the purpose limitation principle is very similar, which is, first, personal data should be processed, lawfully and fairly. That's part of the privacy framework. And second, organizations have to decide. So if they decide to use the data for a different purpose, they have to get consent, or basically the U.S. side has, an opportunity to object, right? So that's a little bit of a difference of how U.S. thinks about it. And the third aspect, so the second aspect is actually called the choice principle. So it's very similar to consent, but it's called choice. So that's a little bit different, but that's a principle.
So yes, speaking about these processing data, what about the so-called special categories of data? Is there anything on that side as well?
So for those who know, in Europe, special categories of personal data essentially is types of data: union membership, sexuality, race or nationality. Those are included. And the U.S. under this data privacy framework also protects the same types of sensitive data. And as a general principle, in order to collect or process those kind of data, there must be express consent from the data subjects, or in the US, the individuals that the data is being collected from.
Okay, and this sounds very close to another of the principles, that is the one of transparency. So, how to inform, I think I would say, those people in particular. What about that one specifically?
Right. So the US calls it the notice principle. The transparency principle is that you let the data subject know that their data is being collected and used. So the US, we take the term notice, and our privacy policies are notices, right? So we have this notice principle which requires organizations to inform the individuals, data subjects, about how company organizations are using their data.
Okay, and another key principle that I think it would be important to share with our listeners today is the one of data minimization, and then also data accuracy, because it's something that is quite well discussed at the EU level. What about the US level on this?
So in the US level, that is brought in with the principle of purpose limitation and data integrity. So in the US, we think of data integrity and purpose limitation principle together, and it covers the data accuracy and minimization principle of the GDPR. So there, the US thinks, well, if you're limiting the purpose, you're only collecting data for the purpose you're processing or using it from. That means you're minimizing the data collecting, and the European Commission seems to agree on that one too.
Okay, and so the GDPR recognize a series of individual rights as well. So is there something like that under the EU-U.S. data privacy framework?
There is. The US calls that the access principle, and it provides the same type of individual rights as the right to access, right? The right to see what information is collected, the right to correct, right to delete. That is all covered under what's called the access principle under the data privacy framework.
Got it. And what about other relevant principles and points of view? In particular, I'm thinking on data transfer, onward transfers, things like these.
Right. So restriction on onward transfers is another principle. Of course, it existed from before, but it goes again into this concept of accountability and onward transfer principle. Again, let's talk accountability first. Accountability is very similar to the EU concept, which is you have to be able to live up to what you promise, that you are abiding and complying with the technical and organizational measures that effectively comply with GDPR. And US also has now an accountability principle under the data privacy framework. So this essentially is not that different from the old US Privacy Shield, which is, each organization says, hey, we're going to be accountable, we're going to comply, and we're going to be able to show that we comply through certification processes, and also allowing US agencies like Department of Commerce, FTC, which is the Federal Trade Commission, and the Department of Transportation to basically regulate them, or at least enforce and investigate if necessary. Now, going back to the onward transfers, there's also the onward transfer principle, which is that data onward transfer can only take place if it's limited, the purpose is limited, and on the basis of the EU-U.S. data privacy framework, and only if the contract requires a third party to provide. So let's say you have a processor, right? You have the onward transfer, and there's a processor in another country. You would again have to have a contractor, something like an SCC, to say, well, the onward transfer, the receiving party will have the same level of protection guaranteed by the principles and the data privacy framework.
Absolutely, and that's an extremely useful indication, I think. Yugo, thanks a lot, because all this was extremely useful and extremely interesting. So thanks to dedicate your time to us and to our listeners, that I would like to thank for being with us today. And looking forward to being together again soon, hopefully with positive news on this draft adequacy decision and its next steps. Thanks a lot again, and see you all very soon again.
Thank you.